My name is Andrew Oldham from the United States Court of Appeals for the Fifth Circuit. Welcome all to this wonderful special session that we have at the Federalist Society. It is an exciting time for this panel on the Second Amendment. As you know, it has been a long time since the Supreme Court has taken a Second Amendment case. We had Heller and McDonald 3 years apart, and then a 9-year break since McDonald before the Supreme Court recently granted cert in the New York Pistol and Rifle Association case, which is currently pending before the court. And our incredible, distinguished panel today is going to have a lot to say about that and other issues implicating the Second Amendment and the right or any restrictions that they may see in the Second Amendment on the right to carry outside of the home. So today we have an amazing panel. I would commend to you their distinguished bios that are in your materials. So I'm going to give very brief introductions of each of them, basically their names and their affiliations, so that we can get started on the substance of what we have to talk about today. So first, to my right and your left is Professor Renee Littau-Lerner. She is the Donald Philip Rothschild Research Professor at the George Washington University School of Law. To her left, Jonathan Lowy, Chief Counsel and Vice President for Legal at the Brady Campaign. To my left, Mr. Mark W. Smith, who is a Presidential Scholar at King's College, New York City. And then to his left, last but certainly not least, John Taylor, who is a principal at Gupta-Wessler. So each panelist is going to have a few minutes to set forth their affirmative views on the issue that's before us today, and then we'll have a slight back and forth, hopefully, with the panelists talking to each other more than to me, and then we'll open up for questions. So without further ado, let me turn it over to Professor Lerner.
Thank you to Judge Oldham for moderating this panel, to my distinguished fellow panelists, and to all of you who are here and watching, and the Federalist Society for putting on this panel. Of all the rights in the U.S. Constitution, the right to keep and bear arms most reflects the spirit of a free people. It's the spirit of resisting oppression. And that oppression can come in different forms: oppression by the government and oppression by private thugs. And the US, as I'll mention in a moment, is not the only place where that spirit exists. It's growing in places around the world. But this spirit is one that causes one to stand up for oneself, for one's family, and one's community. It's the spirit of courage and the spirit of self-reliance. Self-reliance was famously a classic characteristic of the American people. The American people settled a continent in the face of staggering dangers. But in certain circles these days, self-reliance is not a popular virtue. The argument goes, we no longer live on the frontier. We have a specialized police force, and it will keep us safe 24/7. We need to think about whether that's so. Violent crime has not disappeared, but in America today, it is localized. The fear of violent crime doesn't affect me personally much at all. I don't live in a high crime neighborhood, and I never have. Most other suburban soccer moms don't either, and I count myself as a suburban soccer mom, having recently taken my daughter to soccer practice. But mean streets and mean places are not a joke for many persons. A friend of mine became interested in carrying a gun for self-defense because of a new job. That job was being a clerk on the graveyard shift at a motel on Route 1 in Howard County, Maryland, close to here. After my friend had quit his previous job and started work at the motel, he found out the reason for the job opening. The previous night clerk had been shot by a person robbing the motel. A police officer stopped by and mentioned to him that it might be a good idea for him to get a permit and a gun. Such permits were very hard to get. The police approved his application, though, because they were feeling bad about not solving the murder. He got the gun right away and started carrying it. Of course, for persons who live in high crime neighborhoods, these sorts of problems are routine. There's a considerable risk, if you're walking alone at night, that you will be robbed. And that's something that is easy to forget when you're a suburban soccer mom or otherwise upper middle class and insulated largely from violence. Such persons are not likely to hear about the many times that firearms are used in self-defense. Over 67,000 times a year, according to a study by a pro-gun control group using data compiled by the FBI. And that's considered a low estimate, 67,000 times a year that a firearm is used in self-defense. But what a suburban soccer mom is likely to hear about a great deal are criminal shootings. And these shootings play on the fears of an already quivering and anxious society. And so the call goes out, do something about it. Politicians rush to say that they want to ban this or that device that was used, or to end or prohibit legal carrying in public. How effective is that? For that, we can go back to the 18th century. In 1764, the Italian Enlightenment criminologist Cesare Beccaria had something to say about the effectiveness of gun control. He is much beloved of progressives these days because he opposed the death penalty. In his own time, he was famous throughout Europe and also influential with the founders of this country. So here is what he had to say about gun control. False is the idea of utility that sacrifices 1,000 real advantages for one imaginary or trifling inconvenience, that would take fire from men because it burns, and water because one may drown in it, that has no remedy for evils except destruction. The laws that forbid the carrying of arms are of such a nature. They disarm, this is according to Beccaria, they disarm only those who are neither inclined nor determined to commit crimes. Beccaria goes on to say that anyone who's prepared to violate laws against robbery and murder would also violate laws against carrying arms. And he says that a ban on carrying arms would, quote, put an end to personal liberty. 2.5 centuries later, Beccaria nailed it. Criminals find a way to get firearms while law-abiding citizens are disabled. And one of the best examples of this is the UK. The UK government boasts that it has some of the strictest gun control laws in the world. Since 1997, and following a mass shooting at a school, handguns were confiscated. It is virtually impossible to get a license to keep or carry a handgun. The UK International Pistol Shooting Team has to go to Belgium to practice. What happened next? Crimes involving handguns increased by nearly 40% over the next 2 years alone, and had doubled by 2009. Just in late December 2018, within the past 12 months, there was an article in The Guardian about how floods of illegal firearms are now entering the UK, smuggled by organized crime rings. The UK police have made seizing illegal firearms a top priority, but they admit that they can't keep up. And among the most popular of those illegal firearms are handguns, exactly the sort of ban that gun control advocates in the US dream of. Conversely, what do we see when the population is legally armed and carrying? And for that, we turn to the US, and in particular to Florida. Florida, in 1987, became the first state with major urban populations to ensure that almost all law-abiding adults can get a concealed carry permit. Gun control advocates hysterically predicted murder and mayhem on Florida streets. In fact, violent crime went down. License holders almost never misused their weapons. Florida's successful law prompted other states to do the same. Social scientists have yet to find any adverse effect on public safety. So the evidence is overwhelming that gun control not only does not promote public safety, it affirmatively endangers us. And this impulse to prohibit carry is based on, ultimately, distrust of the people and the desire to make the people dependent on government. And this eventually leads to the end of government by the people. Now, unfortunately, the ruling classes over time have taken away the right to keep and bear arms from disfavored groups. And the English did this right off the bat. The provision in the English Bill of Rights guaranteeing the right to keep and bear arms was limited to Protestants only. Catholics were a suspect and disfavored group, and they could be disarmed. And the English further enforced their disarming of disfavored groups through what's known as the game laws, hunting laws, that in effect restricted gun ownership to the upper classes and prohibited the lower classes from owning and carrying. Americans, meanwhile, had their own disfavored groups. After the Civil War, these included African American freedmen. In the former Confederate states, groups were going around disarming the firearms of freedmen, taking the firearms of newly freed former slaves. In response to these confiscations, Congress passed the Civil Rights Act of 1966, guaranteeing to freedmen the right to keep and bear arms. And in the 14th Amendment, ratified 2 years later, is widely understood to have, at a minimum, constitutionalized the Civil Rights Act of 1866. So I'd like to show you a picture of an American, there she is, an American pro-gun advocate, Harriet Tubman. Harriet Tubman usually carried a revolver when she did her Underground Railroad work. But here she is with a long gun because she actually participated in the Civil War as an armed scout. So this is what she looked like when she was working with the Union Army, and she participated in an armed raid in South Carolina. But she was a fervent believer in the power of firearms in the hands of disfavored groups. There is a new movie about Harriet Tubman called Harriet, which was released on November 1st, just a few weeks ago. And the trailer shows her using firearms. I believe I counted 5 times in the very short trailer. So I commend that movie to your attention. Well, in the 20th century, along with the expansion of regulatory government generally, the regulation of firearms expanded, and state and local governments imposed heavy taxes. They prohibited or limited sales of certain types of firearms and created gun-free zones. Some of them imposed complete bans on possession of handguns. And some made it almost impossible for law-abiding citizens to carry a gun for self-protection. Again, these regulations affect mainly ordinary persons, not persons who are upper middle class and otherwise safe from violence. It's interesting that when gun regulations actually do begin to bite, people with power and political connections manage to find a way around them. So, for example, it's telling that William F. Buckley, Nelson Rockefeller, and Punch Sulzberger, the publisher of the New York Times, the gun control crusading New York Times, all had a permit to carry firearms in New York City. But Bernie Goetz, who had been assaulted and beaten on the subway, was denied one. I think it's appropriate to analogize gun laws today with the English game laws. In other words, it's designed, gun control today, by the ruling class to keep control of ordinary persons. Now, there are signs that ordinary people of other countries are getting fed up with being told by the safe ruling classes that they can't have guns. And this is occurring around the world, in France, the UK, Germany, Belgium, and Italy. Perhaps the most dramatic case is Brazil. Brazil is undergoing an epidemic of criminal violence. Brazil has some of the lowest rates of legitimate gun ownership in the region and huge numbers of firearms in the hands of criminals. And there are many, many indications that there is a massive problem in Brazil. Brazil had to send the army to deal with a wave of violent crime in Rio de Janeiro. Ordinary people are wearing bulletproof vests and bulletproofing their cars. School children in certain neighborhoods are getting used to lying on the floor when there's a gun battle. In 2003, Brazil's Congress enacted a gun control law that is appropriately called the disarmament statute. Faced with an onerous registration process, many Brazilians surrendered their firearms. And it's no wonder that Bolsonaro's promise to relax firearms restrictions proved popular. In anticipation of the change, ordinary Brazilians are training at gun ranges. I'm going to show you first a picture of two American pro-gun advocates, Tariq and Geneva Chambers, who are members of Black Guns Matter. And there they are in Philadelphia. You'll observe the pistol grips of their firearms, and notice how Geneva Chambers has decorated hers. I believe that's with some sort of metallic tape. So she likes to put her own special decoration on her firearm. But in Brazil, we have Natalie Ortega. And there she is training with firearms in Sao Paulo, Brazil. And this is what she had to say. She said, right now, only the criminals have guns. I'm not going to run around the streets with a gun in my hand, but a criminal might think twice if normal citizens could be armed. And Natalie Ortega is right. Gun control limits the possession of guns to criminals. The people, especially minorities, women, and the elderly, will be increasingly prey to criminal men. This breakdown, in turn, will cause the victims to turn to government even more. And the government, in response to the crisis of its own making, will continue to expand its already vast powers and personnel. The people will be drained of self-reliance and ultimately drained of spirit, and that is the spirit necessary for self-government. So I'd like to introduce briefly an example of the problem that is very salient today and that Judge Oldham referred to in his opening remarks: New York Rifle and Pistol Association and individual plaintiffs versus the City of New York. And cert has been granted in this case by the US Supreme Court. The situation was this: New York had and still has one of the most restrictive carry laws in the world, in the country. New York City permitted transport of firearms only to 7 authorized gun ranges in the city of New York and to a gunsmith if the owner had permission of the New York City Police Department to do so. The petitioners in that case wanted to be able to carry firearms to ranges outside the city and to be able to carry their guns to second homes. The city fiercely resisted. The city won in the district court and in the Second Circuit. The Second Circuit upheld these severe New York City restrictions and assumed, without deciding, that transport of guns did implicate the Second Amendment. And it also decided that intermediate scrutiny applied, and that Mark Smith is going to tell us more about levels of scrutiny that the circuit courts have used. But the Second Circuit denied that firearms practice is a core Second Amendment right. And it agreed with the city that the regulation protected public safety based on an affidavit from a former commander of the state licensing division hypothesizing that transporting unloaded, locked guns separate from ammunition could be a public safety risk in a road rage or other stressful situation. So that is now the situation, except that then the US Supreme Court granted cert. And at that point, New York City and New York State moved into high gear, in effect to prevent the US Supreme Court from addressing the case. New York City changed its regulation in a very limited way to permit transport of firearms outside the city to a lawful range, not specifying what lawful is, and also to second homes. So the question then arose, is the case now moot? And there's a vigorous discussion about that, separate briefing in the case concerning the mootness issue. The city vigorously arguing that it is moot because the petitioners, according to the city, have everything they want. Petitioners, on the other hand, are arguing that, no, we don't. The city's regulations, for example, require continuous and uninterrupted transport. Apparently, no gas station breaks are allowed, no coffee breaks are allowed in the transport of these firearms. And there is a question of continuing consequences for past violations. It's also unclear what the city means exactly by lawful gun ranges. And even the definition of another residence is unclear. So the city, in effect, has done, and the state, which passed a law prohibiting cities from enacting such regulations, did the absolute minimum necessary to try to moot the case. And the Supreme Court had asked for a briefing on the mootness issue and got it. And in the upcoming oral argument, I suspect mootness will be a significant issue. It'll be fascinating to see what happens, and I suspect that my fellow panelists will talk more about that case. Thank you.
Thank you all very much. My name is John Lowy. I'm with Brady, and I want to thank the Federalist Society for hosting this important discussion and for assembling a truly balanced panel. I think particularly in these divisive times, it is especially important that we engage differing views civilly as we're doing here today. And that spirit is certainly central to Brady. We're a bipartisan, nonpartisan organization. We were founded by Republicans. We are named for prominent Republicans. And our motto today is take action, not sides. Which gets us to what we are talking about today, which is really, does the Constitution allow Americans through their elected representatives to take action to prevent gun violence. To be clear, we are not discussing what Americans should decide as far as gun policy, even though my sense is that this conversation will bleed into that. It seems like it always does when you're discussing the Second Amendment. But the question really is not what our gun policy should be, but who should decide that gun policy. Whether gun policy should be decided by Americans through their elected representatives, which we can all disagree with if we choose, or by judges, with all due respect to Judge Oldham. So the question is, if Americans at the state or national level decide that their communities would be safer if background checks were required before anyone buys a gun to see if they are legally allowed to buy the gun, or that military-style assault weapons should be restricted to the military, or that law enforcement has authority to limit guns in public spaces. If Americans decide that is the policy they want, can they, through their representatives, enact those public safety laws? Put another way, does the Constitution deprive Americans of those choices about what gun laws they want? Does the Constitution require Americans to live in a society where virtually anyone can carry guns and potentially fire guns in public spaces if they deem it necessary, whether in parks, streets, roads, and perhaps further, schools, workplaces, and elsewhere? Are assault weapons a constitutional mandate effectively written in by our framers into the original American pact that founded our government? That's the question. Now, the Supreme Court in District of Columbia versus Heller took one policy choice off the table. Americans cannot enact broad gun bans that utterly deprive responsible, law-abiding Americans of a gun in the home for self-defense. The question before the courts today, and before all of us here today, is, does the Second Amendment take other democratic policy choices off the table too? And any decision that would deprive Americans of those other public safety policy choices must expand upon the Heller decision, because Heller merely held that bans, complete bans of the sort that were in the District of Columbia, are prohibited. And those bans were very rare at the time of Heller, and they do not exist anywhere today. And by the way, Brady, even before Heller, held that as a matter of policy, we did not support those bans. That isn't to say that we thought they were unconstitutional, but we didn't favor them as a matter of policy. So what I'd like to examine in my remarks here today is, does the Heller decision and other jurisprudence provide the sturdy foundation to expand that holding? Does it provide a model for how courts should apply a text, history, and tradition approach, for example, to expand private firearms rights under the Second Amendment beyond what the Heller court decided? So first, let's look at history. And in the spirit of not taking sides, engaging with opposing views, I consulted with the writings of an esteemed intellectual with the Federalist Society and the Heritage Foundation, Professor Nelson Lund, who is in candor, a strong supporter of gun rights, and I believe agrees with the ultimate holding in the Heller decision. But this is what he wrote about the Heller opinion, the majority opinion. And I'll just provide some quotes. Quote, "The court's reasoning is at critical points so defective and so transparently non-originalist in some respects that Heller should be seen as an embarrassment for those who joined the majority opinion." Another quote from Professor Lund, "Justice Scalia flunked his own test. Justice Scalia's majority opinion makes a great show of being committed to the Constitution's original meaning, but fails to carry through on that commitment." A last quote from Professor Lund, "Justice Scalia's Heller opinion itself shows that his use of history and tradition is little more than a disguised version of the kind of interest balancing that he purported to condemn. At crucial points, he simply issued ipse dixits, unsupported by any historical evidence, and at other points, he misrepresented historical facts." Next, there's Judge Richard Posner, a President Reagan appointee. He wrote of Heller, quote, that Heller is questionable in both method and result, and it is evidence that the Supreme Court, in deciding constitutional cases, exercises a freewheeling discretion strongly flavored with ideology. Another quote from Judge Posner, "The irony is that the, quote, originalist method would have yielded the opposite result." And finally, I'll quote from Judge J. Harvey Wilkinson of the Fourth Circuit, another Reagan appointee and formerly shortlisted often for Supreme Court nominations in Republican administrations. He wrote that Heller, quote, "represents a failure, the court's failure to adhere to a conservative judicial methodology in reaching its decision. In fact, Heller encourages Americans to do what conservative jurists warned for years they should not do: bypass the ballot and seek to press their political agenda in the courts." Now, even a cursory, and I'm not quoting anymore, even a cursory analysis of how Justice Scalia analyzed the historical record in Heller shows why these conservatives were so upset with the opinion. And I'll just give one example, and maybe others will come up in our discussion afterwards. In the initial draft of the Second Amendment, James Madison included a conscientious objector clause. His draft read, "The right of the people to keep and bear arms shall not be infringed, semicolon, a well-armed and well-regulated militia being the security of a free country, but no person religiously scrupulous of bearing arms shall be compelled to render military service in person." So in the same sentence, Madison was equating bearing arms with rendering military service. Now, as Justice Stevens noted in his dissent in Heller, this indicates rather clearly that Madison intended a military meaning to the critical term to keep and bear arms. No one suggested that there was a need for conscientious objector clause because people would be forced to possess and use private weapons for private purposes. The issue was military militia service. And the record indicates that the conscientious objector clause was removed over concern that Congress could define who was religiously scrupulous of bearing arms and thereby neuter the militia that was of such concern to the Second Amendment's framers. And no one contends that when the framers decided to delete this provision, that they intended to wholly transform the purpose of the Second Amendment or the meaning of bearing arms. It remained focused on the well-regulated militia that the amendment continued to reference, that is, state armies. Next, let's talk briefly about text. As for how Heller treats text, just consider what is left of the first half of the Second Amendment. quote, a well-regulated militia being necessary for the security of a free state. For American history and jurisprudence up until 2008, this militia clause was accepted as critical to informing what is meant by the second half of the Second Amendment, as it was surely critical to the framers. The pre-Heller reading of what the Second Amendment means was something like this, and clearly I am making up these words to put it into plainer English. A well-regulated militia being necessary for the security of a free state, the right of the people to participate in said militia by keeping and bearing arms to use in that militia shall not be infringed. Now, those who argue for a broader Second Amendment right, post-Heller, I would contend, read the Second Amendment something like this. Again, these are my words, trying to put it in plain English. A well-regulated militia being necessary to the security of a free state, the right of the people, including people who have absolutely nothing to do with said militias, or even people who oppose said militias, to have and use guns with little or no regulation shall not be infringed. Now, a textual analysis would and should draw meaning from the Second Amendment's first half. And I would contend that a broad reading of the Second Amendment makes the first half of it an inconvenience, language that must be argued around and may even be effectively erased as if it were never written. As some put it, what part of well-regulated militia don't you understand? Now, I raise these points not to relitigate Heller. It is the law of the land. But these facts are worth noting when we talk about whether and how to expand upon Heller, or whether we should use the historical or textual approaches that the Heller court purported to apply. Now let's talk a little about tradition, because not just history and text, but tradition also supports interpreting the Second Amendment in a way that preserves the rights of Americans to enact the strong gun laws that they want to protect their communities and families, if they so choose. The United States was founded upon the Declaration of Independence itself, that the core purpose of government is to protect life, liberty, and, quote, safety and happiness. Thomas Jefferson later reiterated that, quote, the care of human life and happiness, and not their destruction, is the first and only legitimate object of good government. Centuries of American gun laws confirm that it has long been understood that the government has broad authority to regulate firearms to protect public safety. And two opinions, there are many, but I'll just point to two, that from shortly after the ratification of the 14th Amendment reflect how courts understood these principles to rein in expansive gun rights. In fact, to save time, I'm just going to give you one of them. The Supreme Court of Georgia, 1874, explaining that expansive gun rights were inconsistent with the framers' vision of a, quote, well-ordered and civilized community. And here's what the court said, quote, to suppose that the framers of the Constitution ever dreamed that in their anxiety to secure to the state a well-regulated militia, they were sacrificing the dignity of their courts of justice, the sanctity of their houses of worship, and the peacefulness and good order of their other necessary public assemblies is absurd. And what the concern was here, that guns would be brought into these spaces. To do so is to assume that they took it for granted that their whole scheme of law and order and government and protection would be a failure, and that the people, instead of depending upon the laws and the public authorities for protection, were each man to take care of himself and to be always ready to resist to the death, then and there, all opposers. Pretty strong stuff. And other courts similarly found that the conception of a broad right, constitutional right, to engage in armed confrontation or carrying firearms in public were anathema to the civil society envisioned by the framers. And the Supreme Court has long construed all constitutional rights to give way to strong interests in public safety. The right to free speech does not entitle the speaker to engage in fighting words because they create too great a risk of a fist fight. The right to freely exercise religion does not entitle snake handlers to endanger worshipers. The right to property does not allow for public nuisances. Miranda rights have been held to give way when police are in search of a single gun because of its risk to public safety. The Second Amendment right to arms also must be constrained by public safety concerns. Even if the court erases the all-important militia language that the framers chose to put front and center in the Second Amendment's text, the well-regulated language also put in that text cannot be so easily dispensed with. For gun regulation runs through American history and is a consequence of long-standing police power authority to protect public safety and the right of Americans, through their representatives, to enact the laws that they need and want to protect themselves. One last point. There are a few threads running through America's founding documents, through Supreme Court case law protecting public safety, and America's history of gun regulation. There's a recognition, sometimes implicit, of one, the right that the founders declared first in creating this nation, the right to live. Two, the duty of the government to protect that right. And three, the recognition that no right may be exercised to infringe on that fundamental right to live. In construing whether the Constitution recognizes a broad right to possess and use private lethal firearms, courts should make sure not to infringe on that most fundamental of all rights. Thank you.
Good afternoon. As Professor Lerner explained, the Supreme Court currently has before it a case involving the right to carry or to bear firearms outside of the home. I submit that the Supreme Court should protect this fundamental constitutional right and make it very clear that government may not ban law-abiding citizens from carrying arms for self-protection, nor may the government limit the right to carry firearms to a few privileged members of the elite, which is the effect, by the way, of these so-called state may-issue laws, which essentially gives certain government bureaucrats the power to decide whether an American citizen has the need or good cause to carry a firearm. Now, in my view, the question of whether or not Americans have a right to carry firearms outside of the home is really quite simple. To begin with, I don't think this is a very difficult question for the Roberts Court. This is true because regardless of the methodology that the U.S. Supreme Court chooses to apply in a question of whether or not one has a right to carry guns outside the home, regardless of the methodology, the constitutional conclusion remains the same. Fully protecting and enforcing the right to carry firearms outside the home is entirely consistent with the text of the Constitution, and it is also entirely consistent with the ordinary principles of all aspects of constitutional law that we know today. And in the case of carrying firearms outside of the home, the court is not being asked to vindicate or invent a minority right that has no populist nor popular support in America. In fact, the court is only being asked to enforce the right to bear arms against really a very few outlier jurisdictions. And enforcing Americans' constitutional rights as citizens against minority outlier jurisdictions fits squarely within one of the traditional roles of the Supreme Court. That is protecting local minorities from hostile legislation and rules that are out of step with and contrary to the national constitutional baseline of fundamental and other rights. Well, let us just start not with Heller, but with the text of the Constitution, which is where all good constitutional scholars should begin. When we, the people, adopted the Second Amendment, they provided very clearly that, quote, the right of the people to keep and bear arms shall not be infringed. The text is very simple, and it very simply protects not just the right to keep arms, which was the right at issue, not just in the Heller decision, but also in the McDonald versus Chicago decision in 2010. But it also addresses the right to bear arms. So the text of the Second Amendment, to me, these rights are on equal footing. And furthermore, where the constitutional founders decided to limit a right to the house or to the home, they knew how to write that in, which is what they did in the Third Amendment, quartering of troops in one's home, and what they talked about in the Fourth Amendment in protecting your property, your papers in the home, among other places. So if they wanted to restrict the rights to the Second Amendment within the home, they certainly knew how to write that in, but they didn't. History, too, supports the view that the right to bear arms extends outside of one's home. The right to bear arms outside of the home is supported by our American history. We know from Heller and McDonald, for example, that the main purpose of the Second Amendment, the North Star, if you will, of the right to keep and bear arms is the right of armed self-defense. It was well understood at the founding and even long before that because the need of self-defense might arise in public, the right to exercise the right of self-defense extended also to being out in public. William Hawkins, who wrote a widely read treatise of the pleas of the crown, described the doctrine of self-defense in 1716. Mind you that William Hawkins was very well understood and discussed by the Founding Fathers as they drafted, among other things, the Constitution. Hawkins wrote in the 18th century, the killing of a wrongdoer may be justified where a man kills one who assaults him in the highway to rob or to murder him. Beyond that, we also know that the founders of the Constitution in our country actually lived the experience of having guns outside the home for self-protection. We know from contemporaneous documentation that Thomas Jefferson was a big proponent of carrying guns, and he even advised it of his cousins and other family members. We know that George Washington would often travel outside with firearms. We know that Patrick Henry would carry firearms. And we know that then future President Andrew Jackson was very well known not for carrying 1, not 2, not 3, but 4 firearms at a time as he rode, among other things, circuit before he was president. In fact, there's a very famous quote of his. 1 year, I believe it's 1 year after the signing and enactment of the Constitution, and 2 years before the enactment of the Bill of Rights and the Second Amendment, that talks about how he rode with 4 firearms in his biography by a prominent historian. But also, we know that in the founding period, there were often requirements, there were actually requirements to carry guns. Many colonies and later states had laws requiring law-abiding citizens to carry firearms in public, such as when they attended church or town meetings. Now, many in the anti-gun community, if you will, argues that our American history does not support, as a matter of fact, a robust right to carry firearms in public. They often point to various sorts of historical laws allegedly restricting that practice. Now, for the purpose of today, to help you and the audience not just learn about the Second Amendment, but perhaps even talk about the Second Amendment when you go back to your communities, I'd like to give you a few ways to think about these these antebellum laws or these examples that sometimes get thrown out there from a historical point of view. And here's a series of questions to think about as you are faced with some of these random and relatively rare laws. First, ask yourself, is it clear that these laws are actually relevant to the Second Amendment? Bear in mind, to the extent they actually rely on ancient English law, for example, can we be sure that the Second Amendment was designed to codify Old English law as opposed to repudiate Old English law? Since, after all, last I checked, we fought a revolution and threw the English out. Next, let us not forget some basic history, such as the shot heard round the world at the Battle of Concord. It's a very strong historical case that the reason why we ultimately fought the American Revolution and became the United States of America, and not just a province of the United Kingdom, was because the British were trying to confiscate guns and powder as they marched out of Boston. That did not work out well, did it? But that history should not be lost, because that common sense elementary school history is not irrelevant to the historical question of whether or not we have the right to bear arms, not only in the home, but outside the home. Second, when you hear sort of anti-gun historical examples thrown out there, ask yourself, are these examples atypical or widespread? Are they really just outlier laws that were in place in only a few unique jurisdictions and often for short periods of time? Third, ask yourself, is there any evidence that these laws were actually applied or enforced? Or were they simply on the books? And if they were enforced, ask yourself, against whom were they being enforced? For example, if they were Southern gun laws, were they mostly being enforced against the poor, against immigrants that were unfavored, or against African Americans that were no longer slaves? Or perhaps in the case of New York City's Sullivan laws, they were just being used against the Italians. A very great quote that I like that was found by scholar Stephen Halbrook, who's in the audience, quotes the New York Times, that's right, the New York Times, where they're applauding a decision to put an Italian in prison for carrying a concealed firearm in New York City. The New York Times referred to the Italian, last name Rossi, as a hot-headed countryman. And then they added, and this is the New York Times quote, the judge's warning to the Italian community was timely and exemplary. Are these the kinds of historical laws that the anti-gun community want to hold up as representative of the best of America and how to interpret our Constitution? I suggest the answer is no. And finally, you must ask, if the founders understood the Second Amendment right to be saddled with all sorts of limitations on carrying firearms in public, then what on the earth does the language, the right of the people to bear arms, actually mean? I submit that the text and history of the Second Amendment shows that it protects a robust right to carry guns outside of the home. Now, in today's world, what many courts, and most of these courts, by the way, are in your usual suspect anti-gun blue states, such as New York, California, Hawaii, New Jersey, Maryland, and Massachusetts. What they've generally done is they skipped over and ignored the text, history, and tradition discussion of Heller and McDonald, and instead applied some sort of a weak T version of intermediate scrutiny. And as we all know, intermediate scrutiny is one of the three traditional tiers of scrutiny. But the fundamental problem with applying tiers of scrutiny to the Second Amendment, or anywhere in the Constitution for that matter, is the tiers of scrutiny of strict intermediate scrutiny and rational basis scrutiny is really just made up by judges. As a recent article in the National Affairs publication by Joel Alicia and John Ollendorf explained, these tiers of scrutiny are judge-made doctrine, which were basically invented in the 1960s as a political compromise between the factions of the Supreme Court in the context of the First Amendment. They have no grounding in the text or history of the Constitution. In fact, during oral argument in the Heller case, none other than Chief Justice John Roberts noted exactly this. Justice Roberts said at oral argument, quote, "These standards," referring to the tiers of scrutiny, "that apply in the First Amendment just kind of developed over the years of sort of baggage that the First Amendment picked up," period, close quote. Well, Justice Roberts was correct. The court should apply the Second Amendment according to its text and history and not these tiers of scrutiny baggage. Not least of which is the Heller decision specifically said that there are certain decisions that are removed from balancing by the government, including by members of the court, which is part of government, because they were found in the constitutional text. But let us even assume for the sake of argument that the Supreme Court were to apply some form of intermediate scrutiny in the New York City case or any other future case addressing the right to carry outside the home. Under intermediate scrutiny, as you probably recall from law school, a law must be struck down unless it substantially advances an important government interest. Now, there is zero evidence that limits on the right to carry to do anything or do anything to advance public safety. And we have lots of data on this because as a matter of statutory law, they do not restrict the right to carry for law-abiding citizens. In fact, 42 states either have a de jure or de facto shall issue system that allows you to carry firearms in public with no permit or with a permit that you get basically just by asking. Now, years of crime statistics in these states demonstrate that people who get a permit to carry firearms in public are incredibly law-abiding. In fact, there's much evidence that people that have licenses to carry firearms are more law-abiding statistically than even law enforcement members. And there's numerous studies that have looked at crime rates across different states more generally that have concluded that there is zero evidence that allowing public carry under a shall issue type system causes any increase in crime rates, and it may in fact decrease them. Which brings me to sort of the final parting thoughts of this presentation. The vast majority of states today respect the right not just to keep arms, but to carry arms, to bear arms. These 6 outlier states restrict that right. And more generally, lawful gun use and ownership remains enormously popular and widespread nationwide, which is contrary to what the mainstream media in a handful of urban areas tell you is the case. For example, this is from Pew, right? Not exactly a right-wing source, right? This is from Pew, a study they did. At least that's two-thirds of American adults have lived in a household with one or more guns at some point in their lives and either currently own a firearm or say that they might own one in the future. Each year, 11.5 million Americans use a firearm for hunting and another 32 million engage in target shooting. And approximately 18 million Americans are licensed to carry a concealed firearm. And mind you that number is deflated. It's undercounted because in about 17 states in America, you can carry firearms without a permit. So the 18 million people with permits don't count all the people that can carry firearms without a permit that don't get counted. So this number, if anything, undercounts the number of people that carry guns in America every day. The right to bear arms is thus extremely popular right nationwide. It is not akin to certain other rights, such as the right to an abortion, for example, used in Roe v. Wade to strike down at a single pen stroke popularly adopted abortion restrictions in 30 states. Instead, the right to keep and bear arms fits an entirely different philosophical model for the Supreme Court and the federal courts as a whole. The Supreme Court's practice of protecting the constitutional rights that are popular nationwide against the infringement of local outliers is what we're talking about in the gun context in the Supreme Court. When the court struck down Connecticut's ban on contraceptives, for example, in the Griswold v. Connecticut case, really all it was doing was enforcing a mainstream national norm against an extremely unusual local law. Likewise, when it invalidated Texas sodomy law in Lawrence versus Texas, this court was merely putting the final period on the handwriting that was already on the wall. So too with the right to bear arms. May issue discretionary carry permit laws are the modern analogies of literacy tests to exercise the right to vote. Gun owners living today in places like Manhattan, Hawaii, and San Francisco and New Jersey face the same challenges faced earlier by local minorities living in hostile jurisdictions such as African Americans in the Deep South earlier in the 20th century. These jurisdictions are out of step with the national mainstream. And I will close with the trend in constitutional jurisprudence over the last 2 centuries has been towards steadily broadening constitutional rights and not shrinking them. The court now broadly protects many constitutional rights that are not even enumerated or mentioned in the Constitution's text. For the court to bless draconian restrictions on the enumerated Second Amendment right based on a handful of outlier historical laws or flawed public policies that deny an enumerated right would simply cut across the grain of historical protections of citizens by the U.S. Supreme Court and the federal courts. And this is yet another reason why I believe that the Roberts Court will view the right to personal protection and self-defense, i.e. the right to carry, as an easy case of constitutional law and not a hard one. And for these reasons, I'm confident the Roberts Court will protect the fundamental Second Amendment right to carry against the infringement of a handful of vocal and elite, but still outlier jurisdictions which are simply out of touch with America when it comes to firearms. Thank you.
Thank you very much. Thanks to the Federalist Society for inviting me. Thanks to my co-panelists. Thanks to Judge Oldham for moderating. It's an honor to be here. I should say at the outset that my wife is pregnant and there is some possibility that she could go into labor at any moment. So if you see me get flustered and abruptly head for the exit, I want you to know that that is the reason why I'm not relenting under the pressure of an opposing argument. Thanks. Judge Oldham mentioned the New York City case at the outset, which is now set for argument in the Supreme Court, and perhaps we can say something about the case in the discussion that follows. But I want to focus my opening remarks where Mark left off, and that is on really what might be the next case to come before the Supreme Court, and that's public carry, and more specifically, whether state law is generally requiring good cause to carry a loaded firearm in public comport with the Second Amendment's guarantee. And to answer this question, I think really the discussion has to begin with Heller. And the question that the court was resolving in Heller, of course, was whether the Second Amendment right protects an individual right or a collective right. And the court resolved that disagreement in favor of the individual rights approach. But in doing so, Justice Scalia's opinion for the court looked not only to the text of the Second Amendment, but also to history and tradition. And for that reason, the opinion is often regarded as a triumph of originalism. In canvassing the history, the court looked first to the English history, which matters because the Second Amendment protects the right to keep and bear arms, which assumes a pre-existing right inherited from our predecessors in England. And then the court looked to the early American colonial laws and the American tradition to understand the contours and the nature of the right as it existed here. And the historical materials that the court looked to were not just limited to the founding era, but extended all the way through the end of the 19th century, making clear that it's not just the founding era documents that matter, but the full sweep of America's tradition. And the conclusion that the court came to after it consulted these historical materials and the text of the Second Amendment is that the amendment elevates above all else the right of law-abiding, responsible citizens to use arms in defense of hearth and home. So that's the core of the right, armed self-defense inside the home. Not necessarily the only right, but the core. But Heller also says that the right is not unlimited. So how do you know what the limitations are? The text doesn't tell you. The text just says the right of the people to keep and bear arms shall not be infringed. You can stare hard at that text all day and you're not going to find in it the answers to difficult questions. And so instead you've got to consult history and tradition. And here's what the court said. We do not read the Second Amendment to protect the right of citizens to carry arms for any sort of confrontation or to keep and carry any weapon whatsoever in any manner or for any purpose. Instead, the court explained that long-standing prohibitions are seen as a kind of tradition-based exception to the Second Amendment and are thus constitutional by virtue of their historical justifications. Examples that the court gave include the prohibition on possession of firearm ownership by felons and the mentally ill, which are notable because these prohibitions, while long-standing in the court's eyes, had been around for only about 100 years or so. And so what the court is saying is you don't just look to the founding era, you also look to more modern laws from the late 19th century or early 20th century. Now, the lower courts in interpreting Heller have coalesced around a two-step approach where you start by consulting the history and asking whether a particular law at issue is longstanding, and if it is, it's constitutional, and if it's not, you then go to the second part, which is applying what has traditionally or typically been intermediate scrutiny, but could arguably be something else. Now, there have been dissenters from that approach, most notably Justice Kavanaugh. When he was on the DC Circuit, he dissented from Heller too, and took the view that Heller mandates a history, text, and tradition-only approach. And so you ask whether a law is longstanding, and if it is, it's constitutional. If it's not, it's not. That's the whole analysis. Most of the courts of appeals that have addressed good cause restrictions have assessed the restrictions by assuming that they burden conduct that is protected by the Second Amendment, and then they skipped to the second part and upheld the laws under intermediate scrutiny. That's a fine approach, but it's not the approach that I'm going to take today. I'm going to instead make the argument, which I think Justice Kavanaugh would find appealing, and which I hope some of the folks in this room would find appealing, that what these good cause laws are is longstanding, and they should be upheld at step one because they are consistent with our historical tradition. Now, in framing the historical question, you first have to have a handle on how the laws operate in practical effect. And so I'm speaking about good cause laws, and the challengers in these cases, and Mr. Smith today they've tried to characterize these laws as operating as a total prohibition on armed carry outside the home, and that is just not true. So if you look to a First Circuit case called Gould versus Morgan, and this is a case that I argued, the plaintiff in that case had requested an unrestricted license to carry a firearm in public from the town of Brookline, and he was denied the license. But he was given the ability to carry a firearm in his home, at work, to and from work, including at night, while hiking, which was a purpose that he articulated as being particularly important to him, and then while target shooting, and under a number of other circumstances. Now, in circumstances beyond those, he was restricted from carrying a firearm. But I think the question then, whether the Second Amendment has any purchase outside the home, which is the question that Mr. Smith focused on, it's a fine question, but it's not ultimately going to answer the question whether a regime like Brookline's comports with the Constitution. I think instead you have to ask whether the restrictions that are imposed find sufficient support in our history and tradition to be deemed longstanding and thus constitutional. For a few reasons, these laws are longstanding. The first is you look to the English tradition, which dates all the way back to 1328 and the Statute of Northampton. And that statute was in effect for hundreds of years, up to and past the English Declaration of Rights, which recognized the right to keep and bear arms, which is the predecessor to our Second Amendment, as the court said in Heller. And that law was a broad prohibition on carrying firearms in fairs, markets, and any place where people congregated in public. There's a decision from the King's Bench in the 17th century that interpreted that law to have no exception for people just peacefully carrying a firearm. The very act of carrying a firearm was considered to be in terror of the people and therefore prohibited. That tradition then took root in early colonial America, where a lot of colonies and states passed mere images of that statute. And then a few decades later in the early 19th century, beginning with Massachusetts in 1836, some states started to take a more permissive approach, and they allowed some form of public carry so long as someone could demonstrate that they had a good cause for doing so. And these early good cause laws, I think, operate very similarly to the regimes that remain in effect to today. Then immediately before and after the Civil War, which is a critical historical moment if you're talking about the meaning of the Second Amendment as applied to the states through the 14th Amendment, over a dozen states and countless municipalities enacted laws that were at least as restrictive as the good cause laws you see today. These laws either entirely prohibited public carry in populated urban areas, or they required a good cause for doing so. A couple of examples from states that I don't think anyone would accuse of being hostile to gun rights. Example 1, West Virginia. It passed a law that made clear that if any person go armed with a deadly or dangerous weapon without reasonable cause to fear violence to his person, family, or property, he may be required to face criminal penalties. Courts construed the self-defense exception quite narrowly to require specific evidence of a concrete, serious threat. Example 2, Texas. It also had a good cause requirement, and its Supreme Court twice upheld that requirement as constitutional. Once in 1873, 3 years after the 14th Amendment's ratification, and then again in 1874. In those two cases, the court explained that the law was, quote, nothing more than a legitimate and highly proper regulation that undertakes to regulate the place where and the circumstances under which a pistol may be carried, and makes all necessary exceptions, including the right to have one at home and at your place of business, just as Brookline does today and a lot of these other jurisdictions do today. The Texas Supreme Court noted that it would be a little short of ridiculous, their words, not mine, for a citizen to claim the right to carry a pistol in places, quote, where ladies and gentlemen are congregated together and without a good reason for doing so. Further, the court observed, the good cause requirement was not peculiar to our own state. Quote, it is safe to say that almost, if not every one of the states in this union have a similar law upon their statute books. That is 3 years after the 14th Amendment's ratification. And the only point, the modest point that I'm making, is that for the dozen states or so that have continued this tradition today, they're not barred by the Second Amendment from doing so. Now, this is not to say that this was the only approach taken by states in this country. There was another approach, primarily taken in the South, that was more permissive. But in that sense, it just mirrors the policy debate that you see today, where one side takes one view and the other side takes the other view. And that is what you would expect in a federalist system. And the question now is whether you want to end that long-standing debate, that policy debate, and constitutionalize it and declare one side right for all time for everyone. And I would submit to you that that's not the right approach. And I'm going to quote a few judges here. The first is Judge Wilkinson, who said, constitutionalizing this critical issue will place it in a freeze frame, which only the Supreme Court itself could alter. Disenfranchising the American people on this life and death subject would be the gravest and most serious of steps. It is their community, not ours. It is their safety, not ours. It is their lives, not ours. to say in the wake of so many mass shootings in so many localities across this country that the people themselves are now to be rendered newly powerless, that all they can do is stand by and watch as federal courts design their destiny, this would deliver a body blow to democracy as we have known it since the very founding of this nation. So that is what is at stake. And as Judge Easterbrook said, the Constitution establishes a federal republic where local differences are cherished as elements of liberty rather than eliminated in a search for national uniformity. When there is no definitive constitutional rule, matters are left for the legislative process. And what is also at stake then is the value of originalism as a method of constitutional interpretation. One thing that Justice Kavanaugh noted, and he drew from Justice Scalia's concurrence in McDonald, is that the Heller test, faithfully applied in his view, will be more determinate, and much less subjective, because it depends upon a body of evidence susceptible of reasoned analysis, rather than a variety of vague ethno-political first principles whose combined conclusion can be found to point in any direction the judges favor. Now, if a group of people can look at the same historical record and see in it their own policy preferences, then originalism is stripped of this advantage. And what you have, as one smart judge has put it in another context, is originalism for me, but not for thee. And that is no originalism at all. Thank you.
Thank you very much to our wonderful panelists and the hat tip. So we have two microphones in the middle of the room. We have about half an hour for discussion. So I'll get us started while folks are lining up, and then we'll take some questions. What I hope will be a lively discussion as we talk to each other. So one thing that all four of our panelists talked about this afternoon is the impact of the Second Amendment vis-a-vis the people and who gets to decide what the rights are, what the right answers to these questions are. So one thing that dawned on me as I was listening to all four of you was that in the Heller decision at page 634, the Supreme Court says the very enumeration of the right takes out of the hands of the government, including the third branch of government, the power to decide on a case-by-case basis whether the right is really worth insisting upon, Justice Scalia's emphasis. So isn't the real question here one of constitutional methodology? That is, do you think that it matters whether James Madison or Thomas Jefferson or Andrew Jackson thought the right was important or linked to a militia? Or do you instead think it's a question of original public meaning? And if the latter, how do we decide that? Rather than sort of who decides more large. In that sense, isn't it really just like every other question in the Constitution, which is how do we figure out what the right enumerated, as the court put it in Heller, really means? So any of you to engage with one another.
Well, should I be sure? I think it's a great question. I think there's several answers for it. I think the first approach, of course, in interpreting the Constitution or understanding a constitutional question is you start with the text. And when you look at the text of the Second Amendment, it talks about the right to keep and to bear, right? Two separate words. If you just say it just has the right to keep a firearm in your home, then what's the point of to bear? That you can like put a gun on your body and walk from the bathroom to the bedroom to the kitchen? I don't think that makes sense from a textual point of view. From an originalist point of view, I think there's a bunch of different ways you can go about being an originalist, right? Some of it requires you to really analyze the Constitution as if it's a statute, trying to understand what people were getting at, what they were trying to address at the time they were adopting the text, in this case, the Constitution. And I think the one thing we probably can agree upon, the purpose of the United States Constitution at the end of the day was really sort of an anti-tyranny protection of individual right mechanism. Everything, whether it's the checks and balances, and you can talk about the structural Constitution, whether you talk about the Bill of Rights, every part of it was about preventing the government from growing so big and dangerous to take away our fundamental rights. And I think the Second Amendment, and other people have written on this, the Second Amendment is just another tool that can be used as an anti-tyranny mechanism to protect our rights. And of course, last but not least, there's the sort of debate. I always like to think there is this sort of debate with Thomas and Scalia about how you interpret the Constitution, where, I think Scalia is a little bit more of a textualist, and I think Thomas has a little bit more of a broad scope of what you look to. I think Thomas, I don't want to speak for the justice, but I think he would say that he does look to things like the Declaration of Independence as inspiring the meaning of the Constitution. And if you look at the backdrop of the Declaration of Independence, it's a very John Lockean philosophy of natural rights. Classical liberalism in the 19th century is this notion out of Locke that we own our bodies and thus we own the rights to the fruits of our labor, right? This sort of notion, this sort of also fundamental, I would argue, to capitalism, because it's based on property rights, which is what you produce with your body. And of course, you also obviously have the right to protect your body, which is your ultimate asset. And even from a Western, Christian or religion perspective, your body is given to you by God, and thus you have the duty to defend your gift from God with self-defense, which would include, among other tools, swords, firearms, whatever. So I think no matter what Western tradition you want to apply, if you want to go beyond the text and beyond originalism, I still think you get to the right answer on the question of, do I have a right to carry a firearm outside the home to protect my life, my family's life, and my community, and my country?
Sure. I need to borrow yours. I think mine's not working. Just briefly responding to a couple of Mark's points. I mean, one, I think the historical record of the Second Amendment is about state power versus federal power. It was not about wanting to make the Constitution a suicide pact or a homicide pact where people could take up arms against all government. It was clearly, and I don't think there's much dispute about this, clearly a concern that state governments that were giving up their sovereignty to some degree could maintain their state armies, which were the well-regulated militias referenced in the Second Amendment, and a concern that if this new powerful federal government wanted to, it could starve or neuter those state armies. And that's why the Second Amendment has this inconvenient first half to it, a well-regulated militia being necessary for the security of a free state. That's what they were talking about.
Okay. Just like to pick up on the judge's point, absolutely, this is an enumerated right in the Bill of Rights. It's specified, and therefore, to a certain extent, limits the choices of the people in the states. To respond to Jonathan Lowy's point about the meaning of the text, it's important to understand what the militia meant in the 18th century, the late 18th century, in the United States. The militia meant all able-bodied men, all able-bodied men. So it was a huge portion of the population, someone in virtually every household. And the concern was, it indeed did have to do with federalism, because the US Constitution gave the federal government power over the state militias, and people in America feared that that power could be used by the federal government to disarm the people. And so that was the concern. Heller was correct. It is an individual right, but there was a federal component to it, that the federal government would use its power to disarm the people. So we need to understand that broad definition of militia back in the late 18th century.
Wonderful. Well, we have a long line of folks to ask questions. So why don't we start at the front mic, and we'll oscillate back, front, or front, back. And feel free to address your questions to the panel generally or to any person individually.
Owen Smitherman, Boston Consulting Group. So I have two questions, one for each side. For John and Jonathan, I want to talk about Young v. Hawaii. Already through Peruta, the Ninth Circuit ruled that you could ban concealed carry based on historical precedent. But they didn't talk about open carry. So in Young v. Hawaii, a plaintiff brought suit saying he wanted an open carry license. Hawaii banned concealed carry. Ninth Circuit already upheld that, so now he's going after open carry. At the trial, the defender for the state said he can't think of any example in which someone had ever been granted an open carry license in Hawaii. And I think through research, they found like 4 concealed carry licenses in the last 20 years. So thinking about these states that have good cause, laws that have been existing for many years, what level of, you could pejoratively say, violation of the Second Amendment needs to happen in order for you to say, that's not just good cause, they're actually destroying the right, this is not okay. And then for the other side, I want to ask about corpus linguistics. Josh Blackman and others have done some analysis of corpus linguistics, looking at the right to keep and bear arms. And sort of in contrary to our view of the bearing arms as sort of carrying, they found that the majority of uses of those words back around the time of the founding ratification was in a military sense. And this kind of picks up on the point that was just being discussed. But how would you respond to this? That it wasn't really an individual right to bear arms as a person outside the home for carrying for self-defense, but the right to keep and bear arms was really more of a military view. Does that change the reasoning that supports more of an expansive Second Amendment? And if so, was Heller correctly decided but incorrectly reasoned? Sit down.
And in the interest of time, I'm just going to ask that, in the interest of time, let's just ask that we keep our answers as short as we can so we get as many questions.
I'll try to be very succinct. Your first question is a great one, and I think it's why it's important for any court that is assessing the constitutionality of a law to ask what the law not just says in its text, but how it operates on the ground, what its practical effect is. And if it turns out that a particular law in practical effect is not a good cause law, but a good cause law in name only, and actually operates as something more akin to a total prohibition, then I think you would have to analyze the constitutionality of that law potentially as if it were a total prohibition, and that is a different historical inquiry.
On corpus linguistics, so the idea behind corpus linguistics is that you can tell the meaning of the word by big data, basically by analyzing massive amounts of examples at a particular time period, in this case, the late 18th century, and determine what the words meant. So I think the use of corpus linguistics here illustrates the limitations of the method. What's been discovered, not too surprisingly, is that to bear arms was generally, in the late 18th century, used in a military context. This is not too surprising that that would be the case. But again, that is not understanding military context at the time. That the military consisted of, again, I say, of all able-bodied men. So a very large portion of the population. We tend to think of the military today as a very specialized groups, relatively small compared to the rest of the population, group of people. That is not the way the 18th century persons thought of it. They thought of military service as essentially coterminous with citizenship.
Let's go to the back mic now.
Yes, thank you very much. Thank you for this great panel. My name is Howard Klein from the Salish State of Florida. The question I have is, we've been talking about the Second Amendment and what it means and parsing the words and the phrases. But let's assume, for the sake of argument, that the Second Amendment didn't exist. We all agree that there has been since time immemorial a right of self-defense, and that right has been cabined by various regimes at various times, but it's a right that's been well recognized for centuries. And I would ask if whether or not the right of self-defense should be the kind of the ultimate right of privacy. And if we look at the right of self-defense or the right to keep and bear arms through the lens of privacy, the Supreme Court has already told us in several cases that the right of privacy can be only infringed under a strict scrutiny standard. So why do we not, or do we come to a different conclusion about the level of scrutiny if we view the right of self-defense as the ultimate right of privacy, the privacy to protect one's own body.
In my view, I do think that there is an unenumerated right to self-defense and an unenumerated right to life beyond the text of the Constitution, approaching the question from, again, like a Lockean natural rights point of view, which I do think really illuminates the Constitution itself. And certainly if you understand that, the Locke role in the Founding Fathers thought about the Constitution and what was important to protect, and I forgot how many references to property and contracts and the like there are in the Constitution, but I believe it's something like 25 references. I think, you could infer that the right to property, which really is derived from your right to go out and do something to acquire the property, again, comes back to the point, if you have a right to your body to generate that property, it seems you have an inherent natural human right to protect it. And I think the right to self-defense and the right to protect yourself and your family is an inherent fundamental human right over and above anything one might find in the Constitution itself. But I don't think we have to get to those esoteric theoretical questions, because I think we have an easy answer here with the text of the Second Amendment.
And I just want to briefly respond to a point that's been made a couple of times, that the militia drew on virtually all able-bodied men, which to me doesn't address the point that those able-bodied men were participating in a militia, and they had arms to participate in a militia, and which was subject to well-regulation. And so I don't think it advances the argument to just talk about the fact that the populace that militia was drawn from.
I think the well-regulated includes, most importantly, the right to keep and bear arms by the general population. So I think that's the answer to that. But I want to emphasize self-defense. Clearly, the framers, the founders, had in mind self-defense. And I agree with Mark that the Second Amendment should be read and thought of in the context of a natural rights idea, and in particular of self-defense. And Jonathan Lowy mentioned Nelson Lund. Nelson Lund has been one of the foremost illuminators of this idea of self-defense as applied to the Second Amendment. And he has emphasized the ideas of John Locke, William Blackstone, Beccaria, whom I mentioned, and Adam Smith, all of whom thought that the right to bear arms was necessary for self-defense and personal safety. Blackstone, who was relied on heavily by the framers, said that the right to keep and bear arms was indispensable to what he called, and I'm quoting here, the three great and primary rights of personal security, personal liberty, and private property. And he said, this right is, quote, the right of resistance and self-preservation when the sanctions of society and laws are found insufficient to restrain the violence of oppression. And those were the ideas that the framers of our Constitution were drawing on.
Let's go to the front, Mike.
Good afternoon. My name is Bob Bird. I'm from the state of Iowa. And following up on a point raised by Dr. Lerner, I've got a question for Mr. Lowy, I believe, concerning the inconvenient first half of the Second Amendment. The state of Iowa in 1857 adopted in its constitution a provision to the effect that the militia shall consist of all able-bodied male citizens from the ages of 18 to 45. The legislature never, to my knowledge, thereafter made any provision either for the armament of that militia or for the storage of their weapons in armories or in any other depositories. The expectation, I believe, was that the armament of that militia was to be provided by the members thereof out of their own resources and kept by them in compliance with other applicable laws. Is Iowa an outlier, sir? And does this help us understand what militia meant at the founding, in the founding period?
Well, I don't want to speak to Iowa law because I don't know anything about it, to be honest with you. But I think the Stevens dissent and the Scalia majority in Heller, I think, set up the historical argument. I think Justice Stevens got it right as to the meaning of the Second Amendment, and I've talked to that. I do think moving forward, given Heller is unquestionably the law of the land, I think it's just instructive to note some of the perils of lawyers and judges playing historian, to be frank. None of us, I think, are trained as historians. It's not what we do. It's not, I don't think it's a class in law school. And, it becomes sort of a appellate battle of the historical experts. And as people have said, it is interesting how people's view of history aligns absolutely perfectly with their policy preferences every single time. And this is not a slam one side or the other. I think it's both sides of the debate, and that should give one pause in putting too much stock on that. And I do think that moving forward, interpreting Heller, we do have the language in Heller that longstanding laws remain presumptively lawful. And I think it's incumbent on courts, among other things, to construe that language broadly, because if they take too narrow a view of whether a particular law is longstanding. Is an assault weapon ban longstanding? Of course not. There weren't assault weapons. But there were restrictions on various types of dangerous weapons. They're not going to be specific analogs, but they're going to be broad analogs. And I think courts should recognize what they're good at and what they aren't good at. And this is whatever side you're on. And and then make sure to also be deferential to the right of Americans to self-determination and to, again, enact the public safety laws that they want, which is certainly part of the American tradition.
Now, just building off of that point, I think one reason why you've seen a lot of courts apply scrutiny and just skip ahead to step two is they're just more comfortable doing intermediate scrutiny or strict scrutiny than they are with engaging in a kind of historical analysis and playing the role of a legal historian. And I don't think it's necessarily hostility toward Heller or its methodology. They're just doing what they think is consistent with Heller and that they're comfortable and used to doing. And it could be that the Supreme Court in the New York City case or in some case down the road will insist on a different methodological approach. But for now, I think that helps explain why the courts have done, the lower courts that is, have done what they've done.
I just want to offer one thing. While no one will criticize lawyers faster than I will, the reality is that if you let American law be turned over to the historians, you also have a different kind of problem. We all know the scandal involving Michael Belial, the historian that won all those historian awards based on an anti-gun series of scholarship that, and this is all public, that turned out to be not true. So had we listen to historians, and the historians that gave historians award for being really good historians, we would have gotten all of our history wrong on the question. So if we don't have lawyers look into history and rely on historians, that may not give rise to a good outcome either. But at the end of the day, lawyers are historians. It's our job to go back in time to understand what a statute means, what a constitution means, what a contract written 20 years means, what a will written by a family, 5 years means is applied today. So the only thing that lawyers do in terms of interpreting documents are look back in time, understand what was intended at the time, and apply it in today's world. So I think that lawyers are naturally designed to look back in time, figure out what was going on, apply to today's world, and move society forward.
And I'd like to put in a plug for legal history. I am a legal historian. And some of us do actually try to do history. And we're fortunate to have here today Stephen Halbrook, who is a marvelous historian. So it can be done. And it is relevant to our discussions of the meaning of the Constitution and to the Second Amendment. Along those lines, I'd like to point out that many of the restrictions that have been noted by Jonathan Lowy and Jonathan Taylor had to do, in fact, with restricting arms for, as I said before, disfavored groups, especially African Americans. So I think it's important to keep that context in mind, that many of those restrictions, especially in the late 19th century, were intended to do that. And that is exactly what the Civil Rights Act of 1866 was trying to prevent, and the subsequent 14th Amendment.
I think we've got time for one or two more questions, so let's go to the back mic, and then we'll come back to the front.
Okay. Jonathan Zimmer from Austin, Texas. My question's forward-looking. It's red flag laws. Scalia and Heller said that restrictions on who can keep, on specific classes of people on who that can keep and bear arms, such as felons and the mentally ill, were constitutional. Red flag laws, they can deprive people of guns and the right to keep and bear arms. Basically, a search and seizure and deprivation of right upon a finding of dangerousness found by a judge, but with hearings much later, if at all, under civil standards, and the decisions are ultimately up to a judge alone and not the jury. This has implications not only for the Second Amendment, but also for rights guaranteed under the Fourth, Fifth, and Sixth Amendments, such as the right to trial by jury, right to confrontation, all of those. My question for the panel is, do you think that these red flag laws are consistent with the original public meaning of the Bill of Rights? Can they be drafted to avoid these issues, or are they just an originalist non-starter?
I mean, just yes. I mean, I think they are. And for context, I mean, give a real example of what these what we call extreme risk protection order laws are. Your troubled 16-year-old son is texting and posting that he wants to shoot up his school, or not, let's not say 16, let's say 22-year-old son living in your basement, and that he's a legal purchaser and possessor, but he says he wants to shoot up his college classroom, and he wants to go against, take out some, whether it's Latinos or Federalists or what have you, whatever his agenda is, and he has guns. And the parents want to stop that. And so they go into court, they get an order where those guns are taken away temporarily, and then he's entitled to a hearing. Now, in my view, that is constitutional in that, and it gets back to the right to life, the right to public safety, which clearly the compelling interest in preventing that sort of tragedy, I think, greatly outweighs the temporary, perhaps, deprival of Second Amendment rights.
I think red flag laws are terrible, they're unconstitutional, and should be rejected at every turn. They're totally unnecessary. Right, the argument in favor of red flag laws goes one of two ways. Either there's someone crazy in the neighborhood we need to put away. Every state already has some form of a Baker law that says if you're mentally ill, if you're showing evidence of mental illness, there's a way to take that person into custody, observe them for 24 hours, get them treatment, figure out what the problem is, and if they're mentally ill, then civilly commit them. Every state has this. But to do this, by the way, and this is why, certain people don't like them, is you have to actually follow due process. You have to give them a lawyer. You have to give them mental health professionals. You have to actually do things to protect the right of the person and their bodily integrity, right? The alternative argument is, someone is out there on the internet threatening to shoot up a school. Well, there's already laws in all 50 states that say if you're threatening someone, that's a crime. You can be arrested for it and go to jail. The laws laws are already on the books. So what are the point of red flag laws? This is really designed, and I write about this in my last book, which you all have a copy of on your chair. There's a whole chapter on this. What this is really about is giving people another set of laws to ensnare law-abiding Americans that follow laws into losing a fundamental right to bear arms, to take their guns away. Notice that they only want to take away the guns from these so-called dangerous people. They don't, my view is, if you're too dangerous to be out on the street with a firearm, you're too dangerous to be out on the street, period. That should be the law, and that is the law, and that's how it should remain. Red flag laws are all about giving people an excuse to go after neighbors that have signs in the property, or use the, oh, see something, say something. Well, that's what they do, but trust me, this will be used as a political weapon against lower middle class people and force them to get lawyers and all this sort of things, and they're extremely dangerous. And here's why they're so dangerous: because criminals expect the cops to show up at their house because it's a cost of doing business. It's a tax. They get it. They expect to get arrested. It's just part of what they do. It's their career choice. But ordinary people that have no arrest record, that have never had a problem with the law, that never see the police unless they're walking down the mall or something, these people do a dynamic entry or knock on the door. Somebody with guns and dressed all up and 5 in the morning shows up unexpected. You're asking for extremely dangerous situations. And there's already been one instance in Maryland of a red flag raid of a place causing the guy to pull out a gun on the cops because he didn't know who these people were, and the cops killed this guy.
Well, let's give John Lowy just one quick second to respond, and we were over time.
Yeah.
So.
I mean, the threshold for depriving someone of their liberty, I think rightly, should be higher than the threshold for temporarily depriving a potential killer, mass killer, of their firearms in which they have their right to retain those firearms. I think that's the distinction made in these laws. I think it's a proper one.
Well, thank you all very much for an extraordinary discussion. I'm sorry that we didn't get more chance to take the long line of questions, which is a testament to this great panel. I'm going to beg them to answer more afterwards, but please join me in thanking them for a wonderful discussion.